All right, so my name is Amy Dimitriadis. I'm an attorney and a professor here at the Massachusetts School of Law. And so what we're going to talk about in this final segment is some issues that present in contracts with regards to small business. So let's start off with the all-important question. Do we even need a contract? And the answer is yes. So oftentimes you might have a transaction, a one-time transaction, or you have a transaction happening between parties that have been doing business for years. And there might be a comfort level there. But the answer is a resounding yes. You absolutely should have a contract that's going to spell out the rights, the obligations of the parties. It's going to indicate what constitutes a breach, and it's also going to allow for the appropriate remedies. And so today you could probably go online and Google some form contract, and you think, well, I'm all set, right? I can just print this off, I can download it on the computer. And oftentimes that free option might be considered a little bit more appealing, but it's not. Those online contracts, oftentimes, they have very broad language, and that broad language might not be enforceable in court. And they also include boilerplate language, which the concern is that it's not going to cover your particular business needs, and it's not going to protect your company's rights. So you want to be careful with some of that language that you might find online, because you might not be protected through it. So some of the stuff that we're going to talk about tonight is the applicable law that applies to your particular transaction. We're going to talk about contract formation, contract enforceability, and more specifically, perhaps unenforceability under the statute of frauds. We're going to talk about various ways that parties have been excused for not performing under the contract. Then we're going to close off with talking about some common clauses in business contracts, choice of law, choice of forum, and arbitration clauses. So let's start off with the applicable law. The law that applies to your particular contract depends on what kind of a contract you're entering into. If you are entering into a contract for services, then common law is going to apply. Common law, judge-made law, case law. If you are going to enter into a contract for the sale of goods, then the UCC is going to apply, the Uniform Commercial Code, as it is adopted by the states. The Uniform Commercial Code has been adopted by the Massachusetts legislature, and we find it under Mass Gen Laws, Chapter 106. And Article 2 of that chapter applies to transactions involving the sale of goods, regardless of merchant status. Oftentimes we think this is a commercial code, and so we have to have merchants in order for the UCC to apply. And that's just simply not the case. If I, as a law professor, sell an item to you, a good, as a law student, neither one of us would be considered merchants. Because it is a transaction for the sale of goods, Article 2 is going to apply, okay? Of course, actually, I should mention, there are certain provisions within Article 2 that require merchant status, and of course, those would only apply if you have merchants, but the entirety, the code itself, there's no requirement that there be merchant status. So at common law, so when you have a contract for services, in order to form a valid contract, you have to have an offer that's clear and definite. There has to be an acceptance of that offer without changing the terms, without adding anything to the terms, and there has to be bargain for consideration that binds the parties. Under the UCC, however, which again applies to contracts for the sale of goods, the standard is a little bit more lax, making it a little bit easier to find the formation of a contract. And so in order to form a contract under the UCC, we need an intent to be bound, and we need a reasonably certain basis for a remedy. And the standard itself, it says, any manner sufficient to show agreement. So it's a much lax or a much looser standard in finding a valid contract under the UCC. Now, of course, in forming a contract, we need legal capacity. The parties have to be able to enter into a contract. Both parties intend to be bound by that contract, and we have to have what we call a meeting of the minds. So both parties to that contract understand the other party's objective intent. So another common question, does that contract need to be in writing in order to be enforceable? There's oftentimes this misconception that only contracts that are in writing are enforceable, and that's simply not correct. There's only certain types of contracts that fall under the statute of frauds. And if they fall under the statute of frauds, then the statute of frauds has the requirements, one of which is a writing. So the statute of frauds basically serves as a defense. If your contract falls under one of the type of contracts that require a writing, and you don't have a writing or you don't have a sufficient writing, then the statute of frauds would serve as a defense against enforcing that contract. Now, of course, it's always prudent and it's good practice to require written contracts, to require signed contracts, but it's not correct to think that all contracts have to be in writing in order to be enforceable. So under the statute of frauds, as it pertains to the items we're talking about today, the two types of contracts that would require a writing are contracts involving the sale or transfer of real estate, and we find that under Mass Gen Laws, Chapter 259, and then contracts for the sale of goods $500 or more, and we find that in Mass Gen Laws, Chapter 106. So if your contract falls under the statute of frauds, meaning that the contract has to be in writing, it has to be signed by the party to be charged, and the reason for it is in essence to avoid fraud. But the statute of frauds doesn't simply require a writing. Under the law, it has to be a sufficient writing. And so what the statute means with regards to a sufficient writing is one that shows that a contract has been entered into, it includes all the essential terms, and it is signed by the party to be charged. Signed by the party to be charged simply means the person against whom we're looking to enforce that contract. Generally speaking, that'll be the defendant if a dispute has already arisen, and so we have a plaintiff and a defendant. And under the UCC, the standard for signature is pretty loose. So any name, any mark, any symbol, as long as there is an intent to authenticate the writing, would satisfy the signature requirement. So X marks the spot, thumbprint, a little dot, a little heart, whatever it is that you include in there, as long as there is an intent to authenticate the writing, then that would satisfy the signature requirement. So you might be sitting there and thinking, listen, I heard you before, you said we need a writing, you told us it's prudent to have a written contract. Why do I need to worry about contract formation? Why do I need to worry about contract enforceability? Why do I need to worry about the statute of frauds? Well, one main reason, which is the topic I'm going to talk about next, is because the ways in which we are communicating today, the various ways in which we are communicating today, are developing much faster than what the law is. And so oftentimes we communicate through text messages, emails, online messaging. And so the question now becomes, well, can those types of communications form a valid and an enforceable contract? And the short answer is yes. You can form a valid and an enforceable contract through an email, or through email communications, through text communications, through online messaging, those instant messages, direct messages and so forth. And so then the next question is, well, even if there is no signature, well, remember how loose the standard is for signature. Any mark, any name, any symbol with an intent to authenticate the writing. And so again, the short answer is yes. So under Massachusetts law, email communications have been found to satisfy the statute of frauds. And what the courts have found is that the typed name at the end would satisfy the signature requirement. Now, some not so recent decisions, but I guess in the long scheme they are recent. One is from 2012 and the other one is from 2008. Both Massachusetts cases, they found that emails can be writings that satisfy the statute of frauds, and they can bind the parties. As long as the court found that, as long as the parties intended to be bound by the emails, and also they found that the parties had formed a clear and complete agreement, including the material terms. The Feldberg case actually noted, which I found an interesting quote, "In truth, the courts have not yet set forth rules of the road for the intersection between the 17th century statute of frauds," which is still good law, "and 21st century electronic mail," right? So what we're trying to do is we're trying to apply 17th century law to our communications today, emails, text messages, messaging, and whatever else we can come up with in the years to come. A case in 2016 that came out of the Massachusetts Land Court was actually dealing with a novel at the time issue in Massachusetts. And the issue that that court had to decide was whether text messages qualify as a writing under the statute of frauds. And what that court found was yes. The court held that as long as the text messages contained all the essential terms, writings of relative informality and brevity can constitute a valid and enforceable agreement. And so, we tend to think of valid contracts with those that are in a, packet of 20, 30 pages, stapled together, signed with a fancy feathered pen in a conference room, a bunch of attorneys. I'm exaggerating, but you get the idea. And that's just simply not the case. The recent case law is suggesting that even when you have something as a relative informal and a brief communication, that could still satisfy the requirements to create binding and enforceable contracts. In New York, a court held that instant messages were treated the same as text messages, and thus they could also be found to satisfy the statute of frauds. Again, similarly, writings of relative informality and brevity can constitute a valid and enforceable agreement. So of course, there's caution there with the communications that you want to be careful that you're not binding yourself or your business to agreements through these types of communications. We do have courts who have found various bases for excusing parties for not performing under the contract. We can refer to these as defenses, excuses for non-performance. They're basically ways for people to get out of contracts, right? And so if you have a contract which it is a contract for illegal activity, parties that enter into a contract under duress, fraud, or undue influence, if the parties misunderstood a basic element of the contract, both parties, so we call this a mutual mistake. Other basis, if it becomes impossible to perform under the contract, and that is an actual impossibility. It's not like a metaphorical, like it's impossible for me. It's an actual impossibility would qualify and satisfy the standard. Commercial impracticability. This, as the next slide will tell you, is very rarely a successful defense. Courts have more often than not declined to apply this and excuse parties for non-performance because of how extreme the circumstances have to be in order for commercial impracticability to apply. Think about wartime, think about embargoes, think about those types of extreme circumstances that would allow the courts to apply the commercial impracticability standard. If the purpose of the contract is frustrated, so yes, it is possible to perform technically, but the reason why you entered into the contract is now useless. A frustration of purpose might excuse the parties for not performing. And then we have anticipatory repudiation. And so this is where a party unequivocally indicates either that they are unwilling or unable to perform their side of the contract. And if that's the case, then the other party, the non-repudiating party, could be excused for not performing their part. These are just a couple of slides further explaining some of these, and they're going to be online if you wanted to read up on these. Some of the common clauses that we find in commercial agreements are the choice of law and the choice of forum clauses. So very simply put, these are clauses that identify the law that will govern your transaction and also the location where your dispute is going to be resolved. And choice of law and choice of forum clauses have generally been found to be enforceable in court. So you could have, because oftentimes we think, well, my dispute is going to be heard in Massachusetts, so we're obviously going to be applying mass law. That's not the case, right? You could have a case being heard in Massachusetts in a Massachusetts court, and that court is applying a different state's laws. It could be applying California law, or it could be applying Delaware law. And that could be determined based off of what we call the conflict of law rules. But more importantly for tonight's discussion, they could be determined based off of agreement within a contract. And so what I've included here is just a sample of a choice of law clause that I pulled off of the Netflix website that we, probably the majority of us, have agreed to without knowing, where it says that these terms of service shall be governed by and construed in accordance with the laws of the state of Delaware. So we have agreed For those of us who clicked OK, I agree to the terms of services and agreement, to be bound by the laws of the state of Delaware if we have this type of a dispute that arises from that website against Netflix. Choice of forum clause, and these oftentimes go together. Choice of forum clauses allow the parties to agree in advance where the dispute's going to be heard, which county, which state, and sometimes even what country that dispute's going to be heard. And while the choice of forum and choice of law clauses are drafted very strategically to give the drafting party a better positive and possible outcome, when you sit and think about the drafting of these clauses, it oftentimes turns out that the choice of forum clause might have a larger impact on the outcome of the case than a choice of law would. Because if we have a case that's being heard under Delaware law, like we will if we have an issue with Netflix, substantively, the laws of Delaware might not be that different from Massachusetts law. So whether we're applying Mass or Delaware might not have that much of a difference. But if you're a Massachusetts resident and you have agreed to litigate your claims in another forum, say California, Hawaii, Florida, you now have to consider what the expenses will also be and how that's going to affect your ability to prosecute that case, defend the case. So it adds on to the expenses when you're trying to consider those litigation costs. Arbitration clauses are also common in commercial contracts. They also have been found to be enforceable in court, although courts are more hesitant to enforce them when they're found in fine print. And in essence, with these clauses, parties are agreeing to settle any disputes through arbitration, through binding arbitration, which helps streamline the process a little bit. But you also understand that parties are giving up their right in their day in court and giving up their right to have a jury decide the outcome of their case. So some final thoughts. Remember, we can create contracts and form contracts through written and oral communications, whether we're face-to-face conversations, phone calls, text messages, online, letters, emails, whatever form of communication. Courts can excuse parties for not performing under the contract. Do avoid boilerplate language found online. Do include all essential terms. Set clear performance standards. What am I supposed to do? What are you supposed to do? Define what constitutes a breach. Include a force majeure clause. Basically, give yourself an out in that contract. Include choice of law and choice of forum clauses. Do consider alternative dispute resolutions. And last but certainly not least, do consult an attorney before drafting or signing any contracts. So with that, folks, thank you for your attention. Any questions? My email's on the board.